Welcome to Control and the Law. This is part 2 of a 2-part podcast on how allegations of domestic abuse are treated in private law cases. If I can just take us back to coercive control, because that's really what this is about in domestic abuse. And I think it'd be helpful, Rosemary, for you to give us a definition of what coercive control is.
Okay, so it's not one thing. I suppose that's the important thing about it. You know, you can't sort of point to and say, right, that is the one thing, that is coercive control. The key point about coercive control is that it's a pattern of behaviour, and it occurs repeatedly, but it occurs in a range of different ways. It's kind of an umbrella term for all of the different forms of domestic abuse that we're used to classifying. So, you know, it might be psychological abuse, gaslighting, manipulating the children or using the children to coerce a victim. There might be physical abuse, but there might not be physical abuse. There might be sexual abuse, but there might not be sexual abuse. Exercising what we call male privilege. So, you know, I set the rules in this household and you've got to follow them. It's been called an abusive household gender regime. So it's something that is accumulative, which ends up putting the victim in fear, coercing their behaviour, and essentially making them tread on eggshells to avoid triggering further abuse, or to try to control the perpetrator's behaviour. So because it's a pattern of behaviour, it means that it's likely to be repeated, and it's going to go on until there's some dramatic intervention to stop it. And it also means that you can't dismiss any particular thing as historic, because it all adds up to this overall pattern, which puts the victim in fear and makes them very apprehensive about what's going to happen next. And so it's not something that can be identified by, you know, one allegation or just looking at what's happened in the last 6 months. It is something where you have to look at the overall nature of the relationship and the dynamic within the relationship.
In terms of the perpetrator's mindset, which is what you've spoken about there, Rosemary, it's their attitude, their right to control. It isn't just their partner or ex-partner, it's their children, it's professionals.
Absolutely, yes. Living in this abusive household regime affects the children. And I mean, all of the research that's been done on the effects of coercive and controlling behaviour on children shows that it's very similar to the effects on the adult partner or the protective parent, is that children are also controlled and have their autonomy limited, have their capacity to form healthy relationships with friends, with the protective parent limited. It interferes with the children's lives as much as it interferes with the adult life.
In 2012, the Home Office did a piece of research, didn't it, in terms of looking at domestic abuse. So coercive control is now recognised as the predominant type of domestic abuse. And it's the lens through which, when we're looking at domestics, it's the lens through which we should basically perceive domestic abuse to take place. So there are other types of domestic abuse, but those are relatively rare, I understand, in comparison.
That's the sort of general understanding. And I think that there's also been a bit of a sense in which the concept of coercive and controlling behaviour is sometimes trivialised. It's sometimes glossed as, oh, it's just emotional abuse. But of course, not only is it not just emotional abuse, but the emotional abuse itself over a period of time has really serious consequences for the autonomy and the functioning and the parenting of the parent who is the target of that abuse. Just to say, oh, you know, he controlled this or she controlled that. It's not just about controlling a particular activity. It's a sort of overall sense of who is in control in this relationship, who is in control in this house, setting a set of rules that the other members of the household have to abide by.
Well, it's the instilling of fear, isn't it? And it's the victims being fearful of the response to breaking those rules of the relationship.
It's about power and the exercise of power to control.
When I think of coercive controlling behaviour, I think of it as a way of making the abnormal normal in the victim's mind. I still think there's a gulf in the public's understanding about just how extensive coercive controlling behaviour is, because the impact of it is that you do lose autonomy, you lose insight, you start adjusting your life to mix with the controlling behaviour. And the controller takes you away from people who might hold a mirror up to your experiences saying, well, why is he checking in with you 5 times? You've only been out with me in 5 minutes. Because gradually you will cease to see that person. The person that says, why is it when I ring you, I always get X on the line instead of you? This is your phone. And then the calls aren't made. But the point is that the victim has adjusted their expectations to such a degree and become so insular in order to be self-protective that the ability to see that that is abnormal abusive behaviour becomes correspondingly limited. Whereas if you have a bruise, if you're punched, or for example, if in an attempted strangulation case, you know that's abnormal, that's crossed a barrier. Still, I'm concerned that it's underreported because of those who don't escape, who don't see it for the scourge on society it is. And that worries me hugely because if, despite the numbers that Rosemary's reporting, there is still a sub-cohort of victims who don't see that they have become abused and controlled by that process, then we, even with Rosemary's figures, we haven't bottomed out the degree to which this is an ongoing endemic.
Yeah, I mean, that's certainly true. And when we were talking earlier about identifying domestic abuse in a private law case, and one of the reasons why it might not be revealed or disclosed or identified at an early point of the case is that it's taking the victim quite a long time to understand that the experience that they had was abusive. And often that only occurs when they are in contact with a domestic abuse service and help to understand that what has become normal to them is not normal, that this is an abusive relationship. And then I think that there's huge barriers then to raising it because there's always the question, well, if it was happening, why didn't you raise it earlier? There's a suspicion about raising it now in order to achieve a particular outcome, and acknowledging that it is something that sometimes the victims themselves are not in a position to recognise is also something that the courts are just not really equipped to do.
What we learned in Re-HN, because I was fortunate to be instructed by Jenny Beck, who is now chair of the Nuffield, and the value of being instructed by Jenny was she was able to, because of the poverty of the pay, just how alleged victims coming into the solicitor's office are likely to be greeted. And although we've moved away from this now, she pointed out to me that with the initial short alert queues they have to do, first, last and worst tended to be the first questions asked of a victim, and normally by someone who was quite junior, because in order to make the figures work, it's not seen as something that demands particularly senior or experienced solicitors, let alone barristers. First, last and worst already had a mindset of thinking about physical abuse. And even that couldn't be guaranteed for obvious reasons to bring out really, really deep-seated hurts like rape, which are very hard to talk about to anyone, let alone a stranger. So if we contemplate Rosemary's point about how coercive controlling behaviour is a ongoing theme, it's a bit like grasping fog. You may have some examples which are more easier to detect. So, for example, the mobile phone control access or not having house keys. They, to anyone outside, may well be seen as real red flags of behaviour, but they normally arise not as a first instance control, but after a process by which the victim has started to comply. So, for example, not wearing certain clothes or not seeing certain people. When I talk about grasping fog, that's how many of the people I act for feel they are trying to get a sense of what their former lives were, what their former sense of understanding was, because they've lost it. And they need to grasp through that really, really clouded, vague understanding of how they have changed before they can see how they are now. And so it becomes, in many ways, a counselling process. And yet we, as barristers, or indeed as solicitors, are not counsellors. We don't have those skills. But we do our best to try to get the history. But that demands time as well as insight, which is entirely pro bono, because the system doesn't expect that of us, but we seek to provide it because that's the only way, in fact, you can properly represent someone.
One of the things that I thought was useful about Re-HN was in talking about preparing for fact-finding and the importance of having a statement, not a Scott schedule, a statement which said an explanation of what it was like being in a relationship with the other person, which begins to get at that relationship dynamic, which is important to know about. Whereas the Scott schedule, which itemises things, which imagines that things are disconnected from each other, and which imagines that you can sum it all up in a tiny number of incidents, is completely misleading.
But they're still being used, Rosemary. Absence of it, which has continued, and ReHM was 2021? Then what we end up doing is like a hybrid. I mean, that's one of the reasons we wrote the book, Ian McArdle and myself, because unlike books which are designed, I think, written by people in order to get work in as a self-promotional tool, what we have done is downloaded our collective experience. So I've downloaded 40 years of my practice at the bar, and certainly the years since ReHN, identifying where cases go wrong and what we can do before they come to court to try to get them right. Ian, who's more junior than me, and so therefore deals with these cases day in, day out at different levels of court. I tend to deal with them in the High Court or above, sometimes a county court. He is still grappling with that fundamental failure to get to grips with the essence of the case at the earlier stages. So the book is meant to be, and I hope is, generous sharing of tips and advices on how to get the best, and therefore how, when you get to court, you have done everything you can do for your client in order not to fall into the traps which Rosemary has identified in the report.
It takes me back to Niels Christie's work about what an ideal victim looks like, which is now about 40 years old in a criminal law context, but they have to be weak. They have to be blameless. They can't be in any way related to the perpetrator. The perpetrator has to be one-dimensionally bad. And that is absolutely unachievable for victims of domestic abuse. They can come across as quite belligerent. They don't necessarily come across as weak. Generally, there's cross allegations. Sometimes they behave in a way that certainly isn't blameless, is far from blameless. And of course, they're in a relationship or were in an intimate relationship with the perpetrator. And therefore, they can never make ideal victim status. And yet they're held to that level of scrutiny and accountability. I don't know what you think, Rosemary, about that.
Yes, the expectations on victims, and this is something that we found in both the Harm Panel report and the Everyday Business report, the gendered double standards of expectations in the family courts, the expectations of what mothers should do, which are very different from the expectations of what fathers can do and can get away with. So those two things are absolutely intertwined with each other. So there's a general expectation about how mothers should behave. And then on top of that, there's an expectation about what a domestic abuse victim should look like. And one of the other things that we found, particularly in the Harm Panel report, was about the impact of race and religion and how that intersected with some of those expectations and stereotyping that occurred that made it particularly difficult for racial minorities to make an argument about domestic abuse, particularly where the abuse, for example, was perpetrated by an extended family rather than just by a single perpetrator, or where someone had insecure immigration status and that was being used against them. All of those things add up to the very high threshold that a victim who is trying to protect their children is expected to jump over in order to demonstrate the relevance of the abuse and the ways in which it's impacting on their children.
I was going to say, if I can come in as a barrister, which is cross-examination. We now have, and I think rightly so, a greater understanding about a trauma-informed court, because absent that, a classic cross-examination of, for example, a victim would be likely to elicit silences and pauses and vague answers and inconsistent answers. As someone listening to that evidence, I would contrast that vagueness, that confusion, the inconsistency with the apparent command of the abuser, the controller, with their ability to call up detail, with their ability to cross-reference their denials with evidence that they have. And my worry was, as I said in ReHN, and I've repeated since, is that what we do then is fall into a trope of credibility. Because what we are faced with in that situation with a classic coercive controlling abuser and a classic coercive control victim is the manifestation of everything that victim's been told, which is no one's going to believe you. You're stupid. You can't remember a thing. This is just crap. You're mad. You can't even remember what you did yesterday. And then you put that victim in court and they're being cross-examined by a stranger in front of a stranger with the presence of their abuser, even if not directly because of special measures, but nonetheless as participation for a reason. And they know they're floundering because they can't come up with that detail. And they get desperate and they do come up with inconsistent answers because, as we know from the impact of abuse, it has a very profound emotional, intellectual component. I think it's really important to talk about the forensic process of unreliability. So when victims are abused, there are very many mechanisms that automatically they have to adopt in order to protect themselves. And we in courts see that happening in front of us, and we are magnifying the abuse by expecting them to provide answers in all of those situations where they are going to feel most isolated and vulnerable, and yet so desperate to be believed that the burden upon them of trying to get their history out is just full of such emotional stress. And they're at another critical point because they understand if they're not believed, the consequences for themselves and their children are going to be profound. So trauma-informed court proceedings, understanding that stories take time to be given and not judging someone for a lack of clarity is very hard to achieve when you are the tribunal trying to unravel a conflicted history.
And I think that's what happened in ReHN in your particular case. Is it ReT? Your client's presentation, the judge had made findings about her presentation. But another thing that came out of ReHN for me was about violent resistance or resistive violence. And it's the victim's response to the abuse and the fight back, which is, according to Michael Johnson, researcher, is inevitable, that eventually, and particularly in the case that ReT, where your client had had non-fatal strangulation, had had a plastic bag placed over her head. If that abuser comes anywhere near you, you would want to fight them off because you don't know what they're going to do. And that violent resistance was, I think, seen as bilateral abuse in your case. Is that right?
It wasn't fight back in the context of the attempted suffocation. There was passivity, because passivity is the safest way to be. You know, you are waiting in the hope that you are going to be saved because there's very little you can do there. But in other instances, there was fight back in other types of abuse, the physical abuse, because that desire to stop the point of physical contact means that you're trying to defend yourself.
If we move on to finding of fact hearings briefly. So Rosemary, in your everyday business report, one of the things that was identified was that litigants in person didn't understand that if there hadn't been a finding of fact hearing with findings, there hadn't been a conviction or an admission about domestic abuse, that those allegations are effectively ignored by the court. And within that report, you found that that was confusing for litigants. They didn't understand that.
This is another area where I think the law is not fit for purpose, because fact-finding hearings are such a high-stake exercise, and you're damned if you do and you're damned if you don't. So if there is no fact-finding, then the allegations will have no status. If you positively decide that you don't want to have a fact-finding hearing, then that is tantamount in the court's eyes to saying there was no abuse, which of course is not what many victims mean when they say, I don't want to have a fact-finding hearing. They don't realise, or it doesn't occur to them, that that would be taken as actually conceding that their allegations are baseless. And then if you do have a fact-finding hearing and then there are no findings, or there's minimal findings which don't actually capture the nature of what happened, then the case only proceeds on the basis of what has been found. So in all of those scenarios, you are misrepresenting or dismissing the nature of the abuse, which then means that your welfare decision is based on a wrong premise and the children are going to suffer as a result. For victims themselves, it's terrible, but it's also terrible as far as the consequences for children are concerned.
And the attrition rate within your report, so you've talked about domestic abuse allegations, is it 76 to 87% of the time?
87%, yeah. 4% of cases with fact-finding hearings, yeah.
Yeah. So the attrition rate's enormous. And what are the reasons for that high attrition rate?
Mostly this question of relevance. So in order to have a fact-finding hearing, there has to be contested allegations, which the court considers to be both relevant to the welfare decision that it might make and that it is necessary and proportionate to hold a fact-finding hearing. So for any of those reasons, not relevant, not necessary, not proportionate, it won't be held. The courts bend over backwards not to hold fact-finding hearings for exactly the kind of reasons that Jo has been talking about. Limited resources, they take up an awful lot of time, they introduce an enormous amount of delay in the case because it's really hard to schedule hearings, particularly with the amount of time that might be needed. They might be minimised, but it's much easier not to have them all together. It's much easier to simply ask CAFCAS to try and sort it out. It's because the domestic abuse is being classified as not sufficiently relevant or that it wouldn't be proportionate to spend the time necessary for a fact-finding hearing. I think the other area where the law isn't right or the courts haven't got it right is about the impact of finding domestic abuse, like the way in which domestic abuse then impacts on the welfare decision. And I think in a lot of cases there's a thing, well, okay, there's these contested allegations, but even if we decide them, it's not going to make any difference to the outcome. So that's another reason why it wouldn't be proportionate. And that was the really shocking finding that came out of both of the harm panel, and then we quantified it in the Everyday Business report, that 87% of cases have allegations of domestic abuse. Absolutely no difference in the orders that are made for live with or time with orders, whether the case has got allegations of domestic abuse, the nature of the allegations of domestic abuse. So there's no sense in which the existence of domestic abuse is being seen as being reflected in court orders. So in that context, what's the point of having a fact-finding hearing?
Yep. Jo, what's your view about finding a fact hearing? Should we be having more?
I'd say yes, because I think it's the only way in which there's an independent evaluation of what the gravity of the experiences are, and to give some guidance to the family thereafter about what's safe and what isn't safe. Because in the main, the public, when they come to court, are looking for a safe outcome because they've not been able to deal with that either internally with their partner or with the family support. So they're therefore in crisis. And so when they come to the court system in crisis, we need to deal with that crisis as soon as possible, because every week, every month that we delay some type of resolution increases the anxiety and leads to decisions by default. So, for example, there's an older child who actually appears to be okay seeing their abusive parent, and there may be another member of the family who's willing to facilitate that contact. It's much easier to let that happen rather than go through the trauma of a stressful, expensive, long, drawn-out hearing. And so you get decisions by default. And when the impact of those decisions is relayed to the court, so CAFCAS tells the court that contact is happening, that immediately gives a let-out clause to say, well, if it's happening, then where's the necessity for a hearing? So it comes down to resources again. It's incredibly frustrating when I sit as a recorder to try to find 2 days. It's rare to be able to give more than 2 days to a fact-find hearing. That 2 days is meant to also embrace reading time for whichever judge it is, judgment consideration and judgment delivery time. And so you're leaving very little time other than to hear the bare accounts from the main protagonist, let alone not hearing from family, friends or relatives. That's the system that goes on day in, day out, where there's not enough court days to deal with those cases that cross the thresholds, and those that do are cut down to the bare minimum. So fact-find hearings, I think, are essential, because that then becomes the marker for future decisions about the child that has a resonance in every aspect of that child and that victim's life. Because absent that, for example, absent police intervention in the criminal field, then it's simply disputed allegations. She says, he says, or he says, she says, she says. And that means there is no resolution. So I do think they're a fundamental, because our system's geared out around them, which probably is the moment where we need to talk about Pathfinder, which isn't geared around them.
I don't think there should be more fact-finding. I mean, I don't think fact-finding hearings are the panacea. And I think fact-finding hearings, they're traumatic. It's incredibly difficult. They're a very forensic adversarial process, which is not designed for litigants in person. And there's limits to which qualified legal representatives can, mitigate that. I think that we need a procedure that doesn't even go down that track. Because also I think that, in a way, what's important is not what happened in the past, it's what's the risk in the future. And for the child, and thinking conceptually about risk might be a better way of approaching it.
If you're looking about the impact of behaviour, and I agree we should do going forward, and the impact on the child, what do you do when the behaviour is disputed as between the two protagonists?
So that's why in the harm panel report, we said that there needs to be a different kind of procedure, a procedure that is focused on putting litigants in person at the centre of things because there's so many of them, putting children at the centre of things because we need to hear from children, and putting domestic abuse at the centre of things because it's so predominant in private law proceedings. And what that procedure then requires is for the court to take an investigative approach. So rather than the adversarial approach of asking the parties to put in contested evidence and the court has to decide what the facts are, the court needs to do its own investigation about what has brought this family to the court and what can the court do to try to support the child's welfare. And that's what the Pathfinder process is all about.
But I really appreciated the ability to look beyond what we can currently provide to try to understand and provide a better and alternative way. Because we clearly can't do more within our existing system. There is no money.
Given that there are really limited resources, then you want them to be doing the best that they can rather than continuing to go around the dysfunctional circles that are currently in place. So the way in which Pathfinder does that initial investigation is to include, so rather than the sort of rather minimal safeguarding inquiries that CAFCAS undertakes at present in private law proceedings, where it just checks whether the family is known to the local authority and to the police. That is included, but in addition to that, there will be consultation with the child, so talking to the child or children involved as much as possible. So obviously very young children it's harder, but where it's possible to do so, including the children's voices right at the beginning, everybody has found that that's made a real difference. The agencies that might have real knowledge of the child, because one of the issues with CAFCAS, of course, is that, again, they're strangers who come in, have a 1 hour or 2 hour interview, talk to someone, and then go away and make conclusions that are going to have a fundamental impact on the rest of their lives. And so in that context, it's better to hear from organisations such as the GP or the school or other support services that have a longer established relationship with the family and can provide information about what's been going on and what the issues are and, support that has already been provided. And then the third element is building in the support of domestic abuse services at that very start. So if there are allegations and the victim isn't already in contact with a domestic abuse service, then they'll be referred to a domestic abuse service. People come to court because there's nowhere else to go. Nobody wants to go to the family court. Yeah. They go there because there isn't anywhere else to go and there aren't other sources of support. Providing an alternative source of support sometimes actually deals with quite a lot of the issues. And so the heat is taken out of the family court proceedings because other forms of support are being provided. But the missing piece of the puzzle, what we didn't have, was the experience of the families who had been through the process. So that evaluation has just come out. It's not totally 100% positive, as you would expect. There are things that can still be improved. There were still children who were, less than satisfied, and particularly victims of domestic abuse who were less than satisfied about the way that the process had been conducted and the outcomes of their cases. But there's certainly a much higher level of satisfaction than, we saw, for example, in the harm report.
So drawing this to a close, I think I'm going to invite both of you to give a manifesto for change. If there's 1, 2 or 3 things that you think are essential to change the system for the better, what would those things be?
Bear in mind, I am a creature of the court system because that's what I do. I'm an advocate within the court system. I'm a judge within the court system. I am therefore going to answer it framed on that court system, which until the Pathfinder programme takes off is still our dominant way of resolving these issues. And I want legal aid back for both parties. I want us to be better at listening, and I want better training amidst the legal professions to try to understand how they can best extract and convey a narrative on their client's behalf. So my points are to resources and qualifications and training.
Yeah. And Rosemary?
I think that some of the lessons from Pathfinder could be brought into the child arrangements program proceedings. So one of those lessons is about listening to children. One of those lessons is about being open to information at the outset about what is going on for the family. And that, I think, would be aided by the PD12J and the courts saying our question is, how is domestic abuse relevant rather than whether it's relevant? And I think that would unlock a lot more careful consideration about what is happening in the families that are coming before the court, how that's impacting on children, and what therefore is needed to actually protect children's welfare.
Okay, thank you both very much. It's been a lively and interesting and insightful debate. Just in terms of our next podcast is going to be about how the financial remedy courts deal with allegations of domestic abuse. But thank you both. So thank you, Professor Rosemary Hunter, and thank you, Professor Jo Delahunty, for your time this morning.